Thank you very much.
Thank you.
Thank you. Thank you, sir. So, ladies and gentlemen, now we move on to the third session. So, this session will focus on the complexities of cross-border IP enforcement and litigation management, highlighting the practical challenges organizations face while protecting intellectual property across multiple jurisdictions and the strategies used to manage international disputes effectively. It is my pleasure to introduce a moderator for this session, Natalia, Natalia, a patent attorney, COPA, Copenhagen Patents, Denmark. Joining her as our esteemed panelist is Rajesh Thakurdas Jagasia, CEO of the Right Justice Lawyers and Consultants, Mona Adel, Deputy Manager Trademarks, United Trademarks and Patent Services UAE, Herbert Schmitz, Senior Commercial Advisor and Sales Lead Patent Plus AI USA, and Dania, Fahs, Commercial and Intellectual Property Lawyer, International Arbitrator and Mediator, Argentum Law Network UAE. Thank you so much. Please join us.
Oh, okay, so not
We are having one more panel members, Mr. Leo. Please join him.
Please join us.
Stage. And then just he's
I can wait. I can wait.
because we have also Mr. Rajesh.
So I don't drink.
Hi everyone. Do you need this or is what is do they need microphone? What is your experience? And that? Hello, is it better with microphone?
Yeah.
Yeah, okay. Hi everyone. Ah, yes.
Oops.
Sorry. It's not working? Is there a green light on?
It's off. And now it's on.
Ah, it's on, it's on.
It's on.
It's on, yes.
It's on. Should I keep it on?
One chair. No, we have
Or should
one more.
cut it on?
She's asking for the okay, one more chair. One more member.
A lot of pictures before the panel.
Yeah, there's a lot of pictures. I think that takes a little bit of time.
Yeah, we have to make it fast.
Do you want to have to take a seat or you want to stay?
Must come from backbone.
If I have time, I have space in my suitcase for those awards.
I'll be sitting in the corner. It's okay, I sit here. We can shift.
Oh, yeah, absolutely.
Yeah, sure.
He will be in the podium, so you can have to shift one seat.
Sure, one seat.
Thank you so much. Sorry for the trouble.
No problem.
So good afternoon, everyone. Welcome to our important and a bit hectic session. We had a lot of changes in the panel. I'm also the last moment moderator, almost for this session. But in spite of all these challenges we faced, we are very eager to discuss the topic, which is one of the most important at the moment, and I think we have some important points to cover. We have today the very interesting combination of how we would talk. We will have first the 12-15 minutes presentation from Rajesh.
Yes.
Right? And I think we will start with this if you don't mind.
Okay.
Yes. And then we will have the live session and we will try to have some time for your questions, of course.
So how many of you see me again? Good afternoon, everybody. I'm using the podium because there are some things which I have to read out and some things which I'll explain you from my experiences. So how many of you believe that other person's spouse is your spouse? Someone else's spouse is your spouse. Anybody believes? So that is what intellectual property enforcement is about. It is about infringing somebody else's trademark and using it as your own. That's the first line of statement. So I'll start with my speech. In an era defined by globalization, digital innovations and cross-border trade, intellectual property no longer operates with neat national boundaries. Transnational IP conflicts arise when two or more parties assert competing rights over the same intellectual property across different jurisdictions. That is what the message was I gave you at the first opening statement. These disputes are becoming increasingly common, particularly in industries such as IT, pharmaceutical, entertainment, and manufacturing. Intellectual property, though intangible, is one of the most valuable assets a business or a creator can possess. Trademarks protect brand identity and consumer trust. In today's global marketplace, IP is not merely a legal right, it is a strategic economic tool. Weak cross-border protection exposes right holders to counterfeiting, piracy, and substantial financial loss. One of the defining characteristics of cross-border IP dispute is territoriality. It's a territorial jurisdiction issue. Intellectual property rights are enforceable only in the jurisdictions where they are granted. When infringement occurs simultaneously across multiple countries, determining jurisdiction becomes exceptionally complex. Courts must navigate domestic IP laws alongside international treaties, often producing inconsistent outcomes and prolonged litigations. These challenges are intensified by difference in legal system and cultural attitude towards intellectual property. Trademark valuation standards in the US may not agree with EU. The digital environment has further transformed the landscape. Internet has effectively erased physical borders, enabling copyrighted work to be distributed worldwide within seconds. Online marketplaces, streamlined platforms, and social media have become hotspots for infringements, including sale of counterfeit goods and unauthorized content sharing. Enforcement in cyberspace presents serious challenges. Infringers often remain anonymous, operate across jurisdictions, and rely on intermediaries such as online platforms, internet service providers. Acts of infringement may originate in one country, be facilitated through servers in another, and cause harm globally. This reality underscores the urgent need for international cooperation and coordinated responses. Resolving cross-border issues involves several interconnected challenges. One is jurisdiction, uncertainty, enforcement barriers, cultural and legal differences, and cost implications, because not all companies can afford the cost of doing enforcement and litigation. Emerging technologies offer both promise and uncertainty. Artificial intelligence can assist in detecting online infringement, while blockchain technology can provide secure and transparent IP ownership records. However, their legal recognition and global acceptance are still evolving or developing. And at the international level, frameworks such as TRIPS agreement administered by World Trade Organization establish minimum standards for IP protection. Other instruments like Berne Convention, Paris Convention, and Madrid Protocol aim to harmonize registration and protect mechanism. The World Intellectual Property Organization plays a vital role for offering arbitration and mediation services for international disputes. So I'll come to some practical case laws which I have enforced cross-border in my lifetime practice. One case was for a European client who had an issue with their cosmetic product. We did many enforcements for them in UAE because we were one of the pioneers of intellectual property enforcements in UAE. We cannot name the brand name or the company name. So this case started from 97 or 98 and we did a lot of enforcements in and out, but ultimately they told us to wipe off their counterfeit issue. So we had to go back to the source. The source was definitely that time in China. We started operating in China, opened an office which was already operating there, and we started attending many suppliers. Ultimately we got to the target. When we approached the target, they were not ready or easy to be handled with. So I was in Guangzhou and I traveled to Ningbo, which is northeast China, to get negotiations done and to seize the factory. We had to operate as a trader, and having a trading knowledge also, I approached them and told them that we want to buy, or if you are supplying, we have to know, we have to see the factory, and we are ready to see the factory and place the orders later on. So they said, no, first you have to place the order. If you place the order, then only we will supply you. There was a lot of negotiations. The trap order has to be set, and the client agreed to all the terms and conditions. The terms were very huge that time, very big amounts being asked, like $50,000 start with the negotiable letter of credit. We negotiated down to $5,000 and a non-negotiable letter of credit. The deal happened. We gave them $5,000 and we gave them a non-negotiable LC, letter of credit. Of course, irrevocable, but it was non-negotiable. And when the time of enforcement came, I had in that 2 months time, the period of delivery, I traveled 3 times and kept a watch. We got the factory location, and the last day, we involved 3 countries to get the factory closed down. There was an officer from Singapore, and the local, and me and the company representatives who were on the field. We did not inform the local authorities or the lawyer in China where are we going to do the operation. We kept quiet on that, and when we did the inspection, we informed them the location, and they came and seized the factory. The goods were worth 5 million euros market value in Europe. Another case which happened, it was not exactly cross-border, but it was just an operation which was told to us to be done by a client for whom we did many enforcements in UAE. They had a big issue with their product, which was duplicated 99.9% and sold in retail markets openly. They also could not understand how could the original product be sold below their prices being retail. So the samples were provided to us, and we detected a small difference in the bottle, the product. So we, having leads from this company, we started tracing them down in UAE and happened to meet the owner of the company who was offering in UAE and worldwide. When I met him with a name card from South Africa, a number from South Africa, and he believed me to be an original buyer. When I met him and told him that we are ready to take some goods from you from South Africa, for South Africa, so he believed me and we met for a dinner. I told him I don't need the goods from China. I need the goods to be looking same as original of the product. We had many products listed for him, but we chose that particular product where the company had a problem of counterfeit in the market. So he opened up the whole story that the bottle was manufactured in the factory where the original bottle was manufactured by the company. There was only a difference of one logo below the bottle. So the bottle was manufactured, say, in Siberia. It was got into some country in Europe, and the packaging came from China. And they assembled there to make it a whole product and sell it all over the world. So the country where the item was manufactured was the country where the formula could be easily duplicated. It was a very interesting, of course, complicated case. It went on for months. But ultimately we got to the source, and the company stopped placing order on the original bottle manufacturing company. So here I am explaining you is the cross-border issues. It's not I'm propagating my practice, because we have done many cases all over the world. Just these two cases, one was actually cross-border, one was involving cross-border. How the products are duplicated, counterfeited, and to bring notice, to get this information is not so easy. But only one thing we remembered, I explained you before, that we don't reveal the information. Now if I would have gone in the first case to China and informed the local authorities there, maybe I could have not got the result. So we involve the local authorities, but at a stage when it is required. We don't involve the local authorities unless we know exactly what we are doing. Cross-border issues are definitely there, because local authorities may cooperate with you or may not cooperate with you. Everybody has their cultural practices of enforcing the law in their country or with the clans. And that time when we did the issue, China was number one in counterfeiting. Cross-border issues has to be handled very delicately so that we get results for our clients. Thank you so much.
Thank you very much, Rajesh. I think it's a very nice start of our session, because it's very good and bright illustration of the difficulties and challenges what we have when we come and find ourselves, our clients find ourselves in the cross-border litigation situations. I think Mona, you also have a small presentation, right? Let's proceed with this one.
Yes. Hello everyone. It's a pleasure to see all of you today. So my name is Mona Aidel. I'm a lawyer and a deputy manager at United Trademark and Patent Services. So I work extensively on enforcement matters in the MENA region and some countries in Africa. And I will be happy to share with you some practical insights on what we are saying, what we are facing in the region. So,
would you speak
Louder. I think the mic is not on.
test?
Yeah, no.
Shall I repeat or? So, when we speak about enforcement, any of you face any enforcement case which involved more than one country? Except Talal, because he is my colleague. Okay, so you understand how this is a complex thing, and actually it is more than only a legal exercise, it's a strategic one. So why cross-border enforcement for trademark or any IP right is complex? Number one, because we have different laws in each country, the timeline is different, the language is different, the evidence which shall be used in supporting this enforcement action is different, and there are many actions we can take. Sometimes we prefer to go civil, sometimes we prefer to go criminal, admin. So it depends on which country we are having the enforcement. and also the cost shall be taken into consideration. So it's a complex legal exercise, and actually it needs a strategy before initiating any action. We can't just have a one solution and we are applying it in each country. No, like it depends on each country and on the infringement itself and on the litigation and many considerations, even commercial ones. So number one, before deciding which action we need to take, we need to take care of 5 key factors. Number one is the strength of my IP right. So do I have enough registrations? Do I have a trademark registration or copyright in this country? Do I have prior user than the infringer? So the IP portfolio of my client is very important. Number two, the market importance. So, you know, almost all the countries have infringement, but I need to consider, like, this country, does it make sense on my commercial approach to proceed with enforcement there or not? So the market importance to me is also a key factor, and the enforcement tools. So maybe in UAE we have administrative action, maybe in other country we don't have, so I need to know which tools I have before I decide how to tackle this infringement. Also the evidence. So to have a strong enforcement, I need to have a strong evidence, especially in MENA region. If I don't have sufficient evidence, most probably the enforcement action won't be successful. And the evidence in IB, it is different from one country to another, but for example, it needs to be copyright registration certificate or trademark registration certificate. So even if the country is a member to Berne Convention on Copyright Infringement like UAE, it is still important to have a registration. So yes, it enjoys the automatic protection, but still I need to register locally so I can submit this certificate to the local authorities and so on. So evidence also need to contain the first year of use for this trademark, if it is a trademark infringement, some documents of use like bill of lading, invoices, commercial contracts, and we can redact the sensitive information. So this is usually the type of evidence we are using in the MENA region. And the fifth key factor we need to consider, that I know lawyers, we always need to fight, but sometimes it is really preferable to go to negotiate and make a settlement rather than going to litigation. So in some cases, like if I'm facing infringement with a big company, it might be unintentional, they might don't have enough IP awareness, so it's worthy to consider like negotiation and reaching a settlement, or even if the trademarks are not really similar, it's just we need to protect our class, we can make a coexistence agreement, we can make a letter of consent. So sometimes we don't really need to fight, we need to also consider settlement. So what are the tools we are having for enforcement? We have different tools. As I just mentioned, sometimes we can just make a notice letter without going to litigation. It is very successful, and especially, for example, in UAE, in many cases I'm handling, once we send a notice letter, the infringer really comply and they are afraid to take a litigation, so they will really comply and even sign undertaking to stop the infringing. And in some countries like UAE, Egypt, we have Morocco, we have the choice to make this notice letter through the court, which is really very effective. So it is like the court notary will help us to serve the notice letter, and it is really effective more than sending it by email and courier only. The customs recorder is very important tool, and based on my practice, I feel it is really underutilized. So in UAE, they have a custom recordation of trademark. Yes. Yep. Okay. So for example, if I have trademark registration in the UAE, I have the ability, after taking the registration certificate to register it before the 7 customs authority in the UAE. So we have 7 emirates. We can register before Dubai, Abu Dhabi, Sharjah, Fujairah. So what really happens when any suspected shipment will enter, they will notify the IP agent that, hey, this is the picture, this is suspected shipment, you need to confirm to us if it is original or fake in 3 days. So if it is really infringing shipment, we need to take an action, and then later on it will be followed by court case. But it is very, very important tool, and I really encourage every company to use it because it like the government itself is alerting you to check is it original or not, and then we can take action. We can have this product seized and recycled, so it is very effective and it is lower in cost than going to litigation. In some cases where there is like damages happen, we need to go civil and we need to claim compensation. So civil action, I think all of you know, and it's also important. And in some countries we have admin actions like UAE, where we can go to the DED or Sharjah Dubai Authority or Sharjah Dubai Authority to tackle this infringement down. It is not like criminal, but it's more easy and it takes like 5 days only. And of course criminal, and sometimes we need to consider the online takedown. So for example, one of my clients, they only have domain name infringement. Someone take the trademark and they make this trademark, let us say X.AE. So instead of going civil and litigation and spending too much money and time, we can just tackle this by filing the UTRV for the country code. So we need always to consider and make a strategy of what the tools we have and then take the action. So we don't need to use all the tools together. We just need to focus and make a strategy when to use and what is the right time and what is the right tool. So as I mentioned, the customs is very important, and actually it is in the MENA region, it is very effective in UAE. And it is valid as long as the trademark registration certificate is valid, but also in other countries in the GCC like Saudi Arabia, Bahrain, it is not official, but we can make a letter on annual basis. Like it's not recordation system yet, not fully, but we can make a letter with the trademark and we circulate it to the customs authority. So once they receive any suspected shipment, they will also alert us. So practical, it is working in other countries in the GCC region as well, but not as official and as the system here in the UAE. So here for the companies which are facing like cross-border trademark enforcement, we need first to consider one country to start from, either where I have strong evidence or I have like the infringement is like affecting me commercially, and then I take action in the other countries as well. It is very important to have centralized evidence. Let us say I have infringement in UAE and Saudi Arabia and Egypt. We need to have this centralized, otherwise the client will make translation for the documents with evidence documents in UAE, then they will retranslate it in Egypt, then they will retranslate it for Saudi. So it is very important to have centralized system to avoid unnecessary cost and also to use this evidence where we can use it. It is very important to have a local counsel who is connected to all the jurisdictions where you are taking action. Because I faced one time an enforcement case where, for example, I registered the trademark Mona here and I'm saying it is confusingly similar to Mona X. So I will take infringement action and against the infringer, and I will say this mark is similar to me and it makes damages to me, it needs to be cancelled and so on. Then let us say in Saudi Arabia, the infringer go and file before me. So when I file my mark there, my mark is rejected. So I will file an appeal and I will say this mark is not similar and my mark is entitled to protections, which is totally against what I'm saying here, and this really happens like in many cases. So I need to have a local counsel, and the coordination is very important, otherwise it will be used against me in the other countries as well. As I mentioned, not all the cases needs to end in court. The husband recorder, for example, is very effective tool, and sometimes the coexistence agreements and letter of consent would solve matter where there is really no infringement, and I just need to avoid potential citation. So this is my notes to you. The strategy is very, very important. For example, I just can't initiate an action without a proper study to the infringement case I have. Let us say my mark is being infringed in the market. Okay, Mona, go file criminal action. I will just go without any preparation. Then I will find the infringer already have existing trademark registration which they file or registered in bad faith. Then I will be surprised in the middle of the criminal and I can't go further. Most probably I will lose because, for example, if I did my searches and my official searches before taking the action, I would have known that they filed or registered this mark, so I would, in this case, suggest civil action, cancellation action to remove it before taking the enforcement action. So the strategy and the searches before considering taking any action is very important. So I'm done. I hope everyone, if you have any questions, please let me know, and thank you so much.
Thank you so much, Mona. I would suggest that we maybe proceed with questions at the end of our common session so that you can address them to all the panelists. And I would like further to proceed with discussing the specific strategies of cross-border enforcement of IP rights. But before we go into the details, I would like to start with the very general questions. What do you think are the main challenges of cross-border enforcement of IP rights?
Thank you, Natalia. Yes. Thank you. Thank you, Natalia. I'm glad to be on this panel. It's a joy to be part of this WL legal forum this year. I participated last year, and I'm happy to be here again. The topic of this panel, the challenges of cross-border enforcement of IP rights. I will focus on cross-border enforcement. We know today that companies operate internationally. They expand their operations across different and multiple jurisdictions. And this raises the issue of cross-border enforcement of IP rights. And this comes with a set of challenges. The first challenge actually is that despite that we do have international conventions, such as Berne Convention for copyright, we have the Paris Convention for industrial property, we have also the TRIPS, trade-related aspects of IP under the WIPO, but these international conventions do set some common standards. However, each country, each jurisdiction has its own set of rules, of laws, of enforcement regimes applicable domestically. And this raises actually, practically speaking, a challenge for the party, for the owners of IP rights, challenges for the council, where to initiate legal action. And regarding IP, we all know that IP are, by essence, IP rights are territorial titles, and the protection is granted within the borders of the national territory. In some jurisdictions, protection can be very strong and very proactive. In others, it can be laxer and weaker. Some jurisdictions, we notice maybe a lack of resources, sometimes a lack of political will to enforce IP rights, and we see sometimes safe havens for fake products, for the circulation of fake products and smuggling of fake products. In other jurisdictions, we have more robust enforcement regimes and mechanisms. So we do see a sort of an inconsistent level of protection. This is the first challenge. The second challenge is related to the digital age. The digital age adds another layer of complexity here. And here I'm more focusing on copyright, the category of IP rights in a sense where we're talking about copyrighted works protected by copyright. We know that online infringements, they spread instantly and exponentially. The internet is a borderless space. To track infringements, to track online theft of content is also challenging. For example, your copyrighted work can be hosted on a platform in one country, and the infringer can be on another country, and the server may be also in another jurisdiction. Where to initiate legal action? Where to define the home jurisdiction of the defendant? This is normally the guidelines that we all abide by as counsel. But on the internet, we find that in this virtual world, these issues are not settled practically quite easily. And initiating separate legal proceedings in separate jurisdictions will entail legal cost, as Mona was mentioning. You have to have a local counsel in each jurisdiction, legal fees, not only legal fees, translation sometimes. Most often, if it's litigation before the court, you will have to translate in the local language. Gathering evidence cost. So cost will add up, and engaging in multiple proceedings is not really beneficial for the interest of the client. So the first challenge is inconsistent level of protection. The second challenge, the digital age. Maybe a third challenge that we are facing as counsel, I would say, that the lack of responsiveness sometimes. Online platforms are not quite responsive to enforce always takedown actions. Okay? And we know that in these IP cross-border infringement cases, for the enforcement, urgency and the timely measure is crucial. Imagine a lively broadcasted event. If the takedown measure is not enforced timely, it will be purposeless. If it's enforced the next day, it should be actually enforced lively while the event is being performed or broadcasted. So we see here the essence, times of essence, and the urgency. And this is also a third challenge that we face when we are enforcing cross-border IP rights, especially when we're talking about the digital online broadcasting and transmission of IP-protected works. I can stop here, Natalia. I think these are the main challenges. I would add maybe one last challenge, a lack of coordination. So not only an inconsistent level of protection due to different legal and legislative laws, but also there is a lack of coordination internationally between also sometimes enforcement governmental authorities. So I think these in a nutshell are the main challenges that we face.
Thank you very much. Yes, we have still a long way to go, right? In harmonization and working internationally together.
We do. It's a maze sometimes to navigate, and I think all of you agree here that as counsel sometimes, and we'll get to this later on during the panel, what strategy and what are the parameters that we take into consideration when we need to engage in legal action, and we have be talking about that later.
Leo, do you have any further challenges also from the perspective of patent rights?
Hi. So my perspective generally, also patents, but generally coming from US, I represent quite a bit of startup companies in the space of software and AI, and the challenge really is what panelists kind of said before, is that the rights are territorial, but enforcement is global, and associated cost perspective is huge. So unlike, I'm one of those attorneys who tell their clients, if we're in litigation, we've lost. I mean, we've got there, wait, it's not what we need to do. So I come from a perspective of transactional attorney who also I try to choose jurisdiction very carefully and early on, and that's where I think that's where the strength is. That's where I can control the costs and I can leverage whatever I have to leverage. And it starts with NDA. I mean, when my clients come and tell me, well, it's not that important, we're gonna look at the form, it covers blah, blah, blah. I look at this from his perspective of like, where do I enforce? And even within the United States, not talking cross-border, I say, we'll choose New York. They ask me, why do you choose New York? I'm like, because I'm licensed in New York and I can sue in New York, and that's gonna cost you less than for me to hire another attorney to go after somebody. So that's my kind of perspective on that. So there's because of global, as we all understand, global infringement and how quickly we need to react, I always recommend contractually to enforce jurisdiction. And that comes from many different ways, from NDA, terms of use, end user license agreements, whatever else you are using in order to, with your customers, with your supply chain, with whatever that is. Choose jurisdiction carefully because that will make or break your deal. And that's my perspective. So.
Thank you so much. Happy to maybe can add a little bit also from the European perspective, right, in comparison to US. So your main challenges, which you see.
That will be a challenge for me, yes, but I have a different point of view. I'm not a patent lawyer or a trademark lawyer. Mainly I work for a global intellectual property service provider. And we see this from another perspective here. We see a lack of strategy, a lack of tactical, and we see the main challenges are here on a wider view, that it's always a problem of managing these challenges here. These cases, we see that for challenges also the standard reporting system. Challenge is to mitigate the risk. Challenge is the commercial aspect, because you can pump in a lot of money in one litigation case, which at the end has no value for the company, so you spend a lot of money, and the impact is quite low for the company. All these orchestrations of this task here, that's a real challenge, and we see this because we have a different point of view. We see more, the strategy must come from the management, from the company owner, from our clients. The tactic, sometimes people mix it a little bit up with strategy and operation. Strategy, tactic, operation comes from the battlefield. So strategy is clear. The tactic is how to do this, which instruments I need, how do I steer the instruments, and the instruments, the feedback from the instruments are changing the tactic. This means the tactic is, at the beginning is clear, but the changes come from the operational side. And we see in this case could be from the local expertise, and this changes sometimes the tactic. So this means to do this means also that you have a standard reporting system that you can compare apples with apples and all these things. This commercial part is also important, so you do not spend a lot of money which has no influence to your reputation, or you underestimate this and your reputation damage is much higher. That's my point of view from a global perspective.
Thank you very much, and I think you touched very interesting points that we start with going in some litigation, right? We start something and we have some strategy, but the situation changes. We get some other information on the different infringements, maybe in other jurisdiction, maybe in this jurisdiction, and we have also the lawyers and the representatives to be very flexible, but also you touched a very interesting point also that the management of the company, right? Those who take the decision, they have to be also flexible, right? They have it's.
Yes, sure. They must also be flexible because and one additional source is AI. Talked about AI. By using AI, you can handle more predictable. It's not that you always trust on AI, but AI is fast. And sometimes it doesn't say you knew something, but it helps you to steer your decisions. Yeah. Mm-hmm. And it's always flexible, must always be flexible, not from the beginning to the end, one straight line. It must be always flexible because the situation can change dramatically in a second. Yeah.
Yes, that's true, and I think the practicing litigators know this very, very well. I don't think we have too much time, but I think we will request a little bit more because we also started a little bit, right? So we will try to be on time. But
Can I add something?
Yes, please, of course.
From my experiences of 30 years, what I believe is give justice. My company name is Right Justice, so we give justice to the client. So when a client approaches us, if there is a cross-border dispute, if there is a cross-border litigation, the client, of course, if it's an MNC, they will not bother. If it's a medium-sized company, they will always bother about the cost. So what we tell them is, don't do small seizures. In UAE also we have done big seizures, giving justice to the client to get enforced that much quantity value that they have lost, and teaching a lesson to the culprit or the infringer that they never do it again. That is my way of doing justice. Of course, we believe in litigation, we all want compensation, but it is good in his country, US, in this part of the world it's no use.
Thank you very much, Rajesh. And also this brings us to the next question, how we actually start. Do you have any tips or hints for the first jurisdiction? Or you would say that it's impossible actually to choose the first jurisdiction. You should try to see it, because we talk about the strategy, right? We should see it from the multiple angles. We cannot just study one jurisdiction maybe and okay, we come to another later. It's also not how it's working. And maybe you have some tips on choosing one or several jurisdictions where you pay more attention maybe, or where you advise, yes, this is how we proceed, how we do it.
You want to answer?
At the end of the day, it is a benefits cost analysis for your client. You need to align with the interests of your client. And you would have to see in which jurisdiction maybe the rights are stronger. And some jurisdictions that provide, as Mona mentioned, for administrative enforcement measures. And this can be interesting because it's fast, it's not expensive, but they might raise due process issues, and they're not always smoothly enforced, and especially not cross-borderly enforced. In some jurisdictions you have the judicial enforcement measures that we are all familiar with, but in some countries, some courts favor the injunctive orders. Some other courts are more comfortable awarding damages. So what does it benefit your client? What type of remedy is being sought by your client here? And we take this into consideration. And I would say finally at the outset, careful drafting of the contract. This is crucial, as it was mentioned. Choice of law provision, it will really spare you the legal headache to figuring out which applicable law, and make sure that the applicable law is a law that is friendly law to protect your interests. And choice of jurisdiction. And here actually you have a choice, not only litigation, but you have arbitration. And the advantage of arbitration would be the global enforcement under the New York Convention. And we all know that now the issue of arbitrability for IP rights is settled in most jurisdictions, so you don't incur any risk by providing for an arbitration clause, for example. Arbitration clause also would help you to preserve your trade secrets. Because you can, when you go to arbitration, you as party, you monitor the process. If you are under the ICC rules, confidentiality is not by default, but you can request to have it confidential. And here you protect your reputation, which is crucial, your commercial reputation, but also trade secrets and sensitive information.
Natalia, can I add? As regard the issue, the jurisdiction issue, usually what happens is when the company faces problem of counterfeits, they locate the markets, because if it's MNC, they have located in 100 countries. So these 100 countries, they give report to the central office that there is a counterfeit issue. So the counterfeit issue is traced back from the shipping back to the country of origin. That time it should be more of China. So they want to trace back it to China. They want to enforce it in China. They want to stop the factory. Now some companies their products are having 400% margin in counterfeiting. They have what out of policy that they allow the shipments, they are already tracked in China, but they come back to the retail market where the goods are sold, and they track the buyers who are buying. So if they stop the buyers, automatically the production stops. So it depends on the product also, where do they start their enforcements.
Yeah, just a quick note, market impact, I think it's very important. I mean, I know I'm coming from US where it's just mainly a large market, but US jurisdictions also not, courts in the US are not happy to grant injunctive relief, especially in IP, and they're gonna spend, I mean, I'll give you guys the price. You spend $200,000 to get injunctive relief, and it's gonna take you 3 months, and you are done. You know, there's nothing to do. So that's kind of a. So there's. I like arbitration. Always use like clauses in arbitration, international agreements. But I think market impact in the U.S. Guys, there are other things you can do in order to enforce. Again, litigation is the last resort. So you know, there's ways to proceed without filing a case just yet, but I think that there's cost and market impact.
It's rare to have, it's not very common to have a US lawyer actually defending arbitration versus litigation.
I don't, but
especially that, yeah. And you have a very robust case law also in the US regarding, so litigation is not always a bad choice, especially in the US in some instances, especially for very specialized IP-related matters like the France, for example. So there is no one-fit-all solution. Okay, so if you want to have an international commercial transaction, you want to have an easy cross-border enforcement, arbitration, New York Convention is very good. Sometimes you have other issues in your mind that you need to account for, and litigation actually might be also an adequate venue.
I have one, yeah. Thank you very much. Back to your question, where to store it. You can store it when you need a lot of information, so you need insights, you need data. If you reach a threshold of information, then you can store it with a strategy, with setups of tactic, and do the right operational steps. But information, data, that's mandatory to store, because you can only manage what you can measure, or when you have a clear picture of that, then you can manage it. And then it's the right point to store it.
One last point, I want to highlight the importance where to proceed and where I have enough and sufficient evidence, because evidence is playing a very important role in the enforcement action. So evidence, yes, thank you.
Documentation.
Yes.
I think we're a little bit out of time, so I would give maybe the possibility at this point to the audience. Do you have any questions or comments which you want to point? Yes, please.
So, thank you for a moment. You were talking about the customer recording.
Yes.
Is it also applicable that if I have a client who has an infringer having a shipment from China to Turkey, but stopping in Dubai?
Yes.
It doesn't enter Dubai.
Yes.
So in transit is also
yes.
working?
Yes.
Okay.
That's why UAE is very, very effective, and we really encourage everyone to use it because it's underutilized.
So it doesn't have to enter the UAE market?
No. Once ever they will suspect, they will inform us, and we have to respond in 3 days, even if the shipment is in transit.
In fact, for some products, they have a scanner at the custom port.
Any more questions? Then I will use this present to ask one small question to the panel from Moderator, the last one. Because
You should be sitting there.
I should be sitting there. That's the role of Moderator.
Last-minute Moderator.
We mentioned the alternative dispute resolution, right? We mentioned arbitration, and Mona also mentioned that sometimes, and also other members, you mentioned sometimes it's much more efficient for the clients to negotiate than to go to the litigation. Do you have experience? Why I'm asking, because I'm from European jurisdiction, and the UPC is developing now, and now also an EU arbitration and mediation center is launching this year, and that's why I'm curious. Do you have maybe practical experience of using mediators while representing your clients and while as the first step of IPL law enforcement, copyright enforcement?
I can. Yeah, go ahead. Yeah, I can answer. I have a very quick answer.
That's okay.
Yeah, just a quick. I don't believe in mediation. Yeah, because I think I don't want to say it's a waste of time, but I think in the U.S. and coming from U.S. attorneys, especially because we're under the license, so we have to, whatever we say is true, kind of thing. You know what I mean? I feel like if it hasn't been done before, mediation is already kind of exhausted itself. But I think negotiation is very important.
I tend to disagree.
Yes, and European perspective maybe also.
I'm a fierce advocate for mediation, which is being underutilized. It's true, not only in IP-related disputes, but in commercial disputes. Although we're seeing a rise of the use of mediation lately. And in tomorrow's panel, actually, on dispute resolution, I will touch on this issue. Mediation can be really very cost efficient. When it succeeds, that's true. But what is the resource being allocated to a mediation process? A few hours, a few days, and you might reach a settlement that would avoid you going to court. So in the balance, if we take the interest of the client, of course mediation should be utilized. I think the fact that it's being underutilized is that stakeholders are not very familiar with the process yet, and they approach it as negotiation plus, and it's not a negotiation plus. So even if negotiations have failed, there is still room for mediation being enabled, a process enabled by a mediator. So I think mediation should be considered just because it's quite efficient. It's just a 1 day or 2 day or 3 day, you have the parties, they sit together and they try to reach a settlement and they try to align not their positions but their interests. And they move from positional to interest-based. And this is important even if the mediation fails because it would have helped them to narrow their issues. And when they go to court later on, they would have done this exercise at least and narrow down some issues. But I agree that it is being underutilized today. However, for IP, we have the WIPO, and if you look at the statistics of the WIPO, they have, I think, quite a load of mediation cases, more than arbitration. So it's quite telling.
Yeah, mediation is a good instrument, but I think it depends on the industry sector where you are. For example, if you compare the pharmaceutical industry with the automotive industry, in automotive industry it works completely different because you could stop the whole production from one day to the other day because one car maker says to the other car maker, hey, I find something. The other one says, I find also something. I find another one. I also find another one. Okay, good. Let's move on. In pharmaceutical, it's completely different. I think they wouldn't work. In automotive, it works. I would say depends. Always depends.
Always.
As a not a lawyer.
Thank you so much.
Mediation is very, very important. It saves a lot of time going to court and getting compensation under the tort law. And it depends on the lawyer how they handle both the sides. Of course, in favor of his client or her client. Mediation is very important, but in this part of the world, we don't get involved. Not in litigation also, and not in mediation also. We just get a seizure done, that is evidence gathering and handing over to the authorities to take action.
We don't fight.
Yeah?
We don't fight.
Because there is no compensation. The maximum compensation somebody has got is 200,000 dirhams, that is $50,000. So in US, yes, if I same case I find it in US, I'll get millions.
Not in trademarks. Not in trademarks.
Thank you so much, and please feel free to approach the panelists in the coffee break for more questions. Thank you so much.
Can I get a round of applause for the panelists? I would request the moderator to present the mementos masses.
From lawyers. Yeah, depends. Always depends. Yeah, the first statement is it depends. It depends on this.
Okay, it's for the session.
I read a lot of patents, but automotive industry is funny. It's great.
Please wait for the group photo also. Dania left.
Oh, is it? Sorry.
I request Mr. Rajesh to present our moderator.
At last we
Thank you so much.
That's my third day. Yeah.
What you?
So please join for a group photo.
So my.
Please join for the group photo.
How do you expect?
What's the trophy?
I think
Trophy, yes. Without a trophy.
Without a trophy.
Without a trophy.
No, it's okay.
No, please. You're the moderator
in the middle.
Without you, we couldn't have done.
In this, but you have to be seen because
You've done this before.
So these cameras are. Look here, sir. This camera.
You have only one camera. You have to look at their one.
Thank you so much for this.
It's time for the lunch break. Please enjoy the spread. And we will resume the session at
Yeah,
5:30.
we have
Thank
a
you.
huge practice in Germany.
Oh, okay.
Yeah, so we have a parallel to speak German, whole thing. Yeah.
Okay.
Yeah, so we can.
Yeah, that's my contact for Denmark.
Okay, perfect.
And I have another header. It's only a consulting group.
Okay.
We do recruiting and sales training for firms. Yes.
Oh, perfect.
It's a group beside Denmark.
Okay.
Today I'm here for Patent Plus AI. Patent Plus AI.
Okay.
So client, and we do on-site sales training. I show him how to acquire clients.
Nice.
Yeah.